particular areas. For instance, most of the cell phone stuff was covered by Special Agent Balance from the FBI. All that information was brought to the team, relayed back out at least twice a day, and then as that information was essentially synthesized, it was put into a running document, a living document that is now known as Exhibit A.
So when it was characterized yesterday as a group effort, do you agree with that characterization of it?
Yes, ma'am.
And do you know approximately how many warrants you worked on in this case?
I don't, ma'am. Several. I don't know the exact number.
Right. I'm going to walk you through several segments of different warrants, and some of this may seem choppy, but I'm going to try to do you and then Detective Mowry at once instead of bringing you back and forth. Does that make sense?
Yes, ma'am. Sounds good.
All right. And Judge, I have paper exhibits for you and for the witness. And so I'll go as fast as I can, but I want you to be able to look at what he's looking at. So we're going to begin with the first AT&T warrant. Prior to this case, had you ever secured an AT&T warrant?
No, ma'am. I don't believe I had.
And so, given that, who did you rely on in creating the warrant?
Largely
AT&T?
Special Agent Balance. Obviously, he's the CAS expert, so I relied heavily on his input.
At the time that AT&T warrant 1 was secured, were you co-located with Special Agent Balance?
I believe so, yes.
Can you, well, in terms of being more specific, it was December 23rd. Were you two co-located at that time?
I believe so, yes.
And I know co-located has been talked about in court a couple of times, but can you just explain what it means for you two to be co-located since he's from DC?
Certainly. Yeah, he was in the same building as I was, just mere feet away from the command post.
Okay, so when you say mere feet away, were you guys in like a cubicle setting, or were you in offices with doors? What was this setting in terms of proximity to each other a few feet away?
Yeah, separate offices with doors, but in the same second floor of the Moscow Police Department.
Are you aware of Special Agent Balance in his work in doing AT&T records having any access to AT&T records without a warrant?
I am not aware of that, no.
Are you aware of him having any ability to review AT&T records through any portal without a warrant?
Not to my knowledge, no.
I'm going to begin with what is known as State's Exhibit 1 attached to their objection to the motion to suppress AT&T warrant. And Judge, for today's purposes, what I'm doing is relying on the labels that are in the record as opposed to giving them new stickers.
This has been marked previously as State's S1, or is that 8-1? I can't.
I think it's SS for State 1.
All right, State's S1 affidavit for search warrant.
And now I've got to get...
Objection to.
On January 24th, 2025, a significant hearing took place in Boise, Idaho, concerning Bryan Kohberger, who faces charges for the November 2022 murders of 4 University of Idaho students. The primary focus of this session was the defense's motion to suppress key pieces of evidence, particularly those obtained through investigative genetic genealogy challenge to IgG methodology. Kohberger's attorneys contended that law enforcement's use of IgG violated constitutional rights. They argued that police utilized IgG without obtaining proper warrants, leading to the identification of Kohberger as a suspect through DNA found on a knife sheath at the crime scene. Validity of search warrants. The defense further asserted that law enforcement misled the court to secure search warrants for Kohberger's personal belongings, including his phone, vehicle, and residences. They claimed that officers either intentionally or recklessly provided false information or omitted crucial details when requesting these warrants. Prosecution's counter-arguments. Legitimacy of IgG use. Prosecutors maintained that the application of IgG was lawful, emphasizing that individuals do not possess privacy rights over DNA left at crime scenes. They highlighted that Kohberger has not alleged that he personally submitted his DNA to any genealogy databases, nor that it was misused. Proceedings and next steps. The hearing included both closed and open sessions. In the open session, arguments from both sides were presented, with Kohberger in attendance. The court is set to continue hearing additional arguments from both the prosecution and defense regarding the admissibility of the DNA evidence. The outcome of these hearings is anticipated to significantly influence the prosecution's case as it moves toward the trial scheduled for August 2025. The FBI also ignored internal federal policy in pursuit of the alleged killer when its agents submitted that DNA to a pair of public ancestry databases that law enforcement is restricted from accessing. It was revealed at a court hearing Thursday. That amounted to nothing more than a breach of private terms of service. Prosecutors rebutted, even as the defense alleged constitutional rights violations over the advanced technique known as investigative genetic genealogy, or IgG, that first put Kohberger on police's radar. Ann Taylor, Kohberger's lead attorney, accused police at the pretrial hearing of intentionally and recklessly sidestepping protocols during the sprawling investigation in their feverish or the person responsible for the violent crime that left 4 dead. IgG had neither been disclosed by police to a prior judge who granted dozens of search warrants in the case, nor included in the probable cause affidavit for Kohberger's arrest. In the process, investigators broke the law, Taylor said, and raised defining questions about modern-day policing. If society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left, Taylor told the court Thursday. I feel as though determinations on the legal issues presented at the all-day hearing could have broad implications for crime-solving tactics going forward and how detectives must conduct themselves when they incorporate DNA evidence into their investigations. Hippler's decisions in the matters may set the course for not only one of the nation's most high-profile murder trials, but also many others that follow. The prosecution came back with the only way to forge a Fourth Amendment argument through the use of IgG would be if Kohberger had previously submitted his own DNA profile to one of the ancestry websites, but not permitted public use of the information, Nye said. Legal experts have previously told the Idaho Statesman that a vicarious privacy claim on behalf of someone's relatives is not a potential path for a defendant in a criminal case. He has not asserted factually or through evidence that he was a customer to one of these databases, Nye told the court. And maybe that changes the case if he were, but he's not. He's not even claiming that. Something I found interesting is we get insight into what one of the roommates have stated. Ann Taylor states there are 2 references to not remembering. And a couple of days later in the third interview, there are references to not remembering being drunk, she said. A statement, I don't know any of it, like half this stuff, I don't know if it was a dream or if it's real. And credibility is really, really important when this person was relied on in the investigation. I hope everyone enjoyed our overview of the hearing, and don't forget to like and subscribe for notifications on our live stream.